Good morning once again, everyone. We will start in about 3 minutes, so kindly please settle down. And there are still empty seats in front. Kindly please move towards the front before we begin. For those at the back, kindly occupy the seats in front. Thank you. Distinguished guests, welcome to Day 3 of the Second National Decongestion Summit. I'm Attorney Mike Navalio, Supreme Court Chief Communications Officer. Magandang umaga po sa ating lahat and maayong buntag. Salamat sa inyong pagtambong. Let me acknowledge at this point some of our very special guests. We have with us Supreme Court Senior Associate Justice Marvic MVF Leonen. Good morning, Sanj. We have representatives from the Department of Justice and the Department of the Interior and Local Government. Court Administrator Maria Teresa Dolores Gomez Estoesta. Honorable speakers, members of the Steering Committee of the Second National Decongestion Summit, JSCC Technical Working Group chairs and vice chairs, and participants from the justice sector, agencies, civil society organizations, and the academe. So good morning to all. So yesterday we have had some very interesting discussions. We started off with a powerful sharing of a person restored of liberty of her lived experience when she was incarcerated and the impact it had on her family. A reminder from our speakers that talking about decongestion should go beyond statistics and should, in fact, consider the persons behind the numbers. So incidentally, yesterday we had 2 breakout sessions talking about UNODC's restorative justice. It's a handbook that they are preparing, and there's also an effort to come up with protocols for women in conflict with the law. There was a session also yesterday about calculating good conduct time allowance credits for PDLs, and the other one was on clinical legal education. In the afternoon, we explained what justice looks like beyond prison, what are the alternatives that can be considered to ensure that there is still justice even without bars. So we had breakout sessions on diversion pathways, strengthening katarungan pambarangay, moderating penalties for local ordinances, and performance indicators for law enforcement other than the number of arrests. So today, we have a packed session, our last day. We will explore innovations to increase releases of PDLs. We have breakout sessions on reintegration programs, penal alternatives, recognizance and compassionate release. We also have sessions on expungement of criminal records and prison audits from paralegal services. You see them on the screen. We also have sessions this afternoon on unification of 2 correctional systems consistent with the Nelson Mandela rules. We have breakout sessions on correctional monitoring, crafting a new jail and prison building code, regulation of prison occupancy, and independent prison capacity measurement. So it's a full day for all of us. Please note that the plenary sessions for this morning and for this afternoon are live streamed on Facebook and YouTube. We also have video recordings of our breakout sessions. So should you have any concerns, please approach us or any of the member of the Secretariat. So we'll go straight ahead to our first plenary session this morning, which will spotlight international and national innovations that expand opportunities for release, sentence review, and collective remedies to reduce incarceration. The discussion will highlight legal strategies, advocacy, and judicial reforms that contribute to lowering prison populations while ensuring fairness and human rights. We have a high-level panel this morning. May I please invite to the stage Patrice Sultan, Executive Director, Center on Race, Inequality, and Law at the New York University School of Law, Nid Satjipanon from the Association for the Prevention of Torture, Senior Associate Justice Marvic MVF Leonen from the Philippine Supreme Court. And to moderate our discussion, we have with us Court of Appeals Associate Justice Ronaldo Roberto B. Martin, who also serves as the Vice Chairperson of the Justice Sector Coordinating Council Technical Working Group on Processes and Capacity Building. Justice Martin, the floor is yours.
Thank you, Attorney Mike. Good morning, magandang umaga po. Ako po ang inyong moderator ngayon. And I'd like to inform you, we will have a very, very sexy topic today, innovation to increase releases. Unfortunately for the hopeless romantics, our discussion will be mainly on those imprisoned under dehumanizing conditions, not being imprisoned under the loving arms of someone special. But if there's anyone who could mix legal provisions and romance, it is our main speaker today. In fact, his good friend, Attorney Danny Concepcion, sir, he told me to mention this. He is otherwise known as the love guru of the Philippines. Hindi po ako yan, si Attorney Danny Con po. So, actually doesn't need any introduction, but as tradition dictates, our main speaker is from the UP College of Law and is well known to explain complicated issues such as this complex issue of jail decongestion. And I'm sure if he's the only person capable of using romantic metaphors to explain such legal issues. Our resource, in fact, this is practically the second time I'll be moderating on jail decongestion involving justice, our esteemed speaker. The first time was 2 years ago, and we had a passionate discussion with officials of the Bureau of Correction who had his own corrections he wanted to espouse, and the BJMP. Our main speaker has innovative ideas precisely to decongest our jail cells. So let's all welcome our main speaker, Senior Associate Justice of the Supreme Court, Justice Marvic S.A. Leonen.
Maraming salamat. Assalamualaikum warahmatullahi wabarakatuh. Isang mapagpalaya at mainit na umaga sa ating lahat. When we gathered in December 2023 for the first National Decongestion Summit, we confronted jail congestion not as abstract statistics, but as a lived reality, the daily experience of persons deprived of liberty, jail officers, prosecutors and public defenders, and judges whose dockets reflect the human cost of delay. The first summit scored the whole of government approach, improving jail management, reducing admissions, shortening detention, and increasing releases. 2 years later, we gather again with many of the same faces, but in a different moment. There has been progress. There have been measurable gains. But there is also a sobering truth. Despite reforms and infrastructure expansion, congestion remains systemic. The problem persists not because we lack effort, but because our systems, many of them inherited, many of them unquestioned, and are now so far removed from the context in which they were created, were never designed for dignity at scale. Many discussions on jail and prison congestion revolve around numbers, cell capacity, backlogs, years served. These figures matter. They guide policy and measure impact. But congestion is not merely a matter of logistics. Over the years, we have learned that it is primarily a design problem, and design problems, no matter how entrenched or complex, can always be redesigned. This second summit rightfully turns our attention to long-term structural and legislative reforms, to redesign in a sense and reimagine the ways in which we may improve our systems across all three branches of government. My task this morning is to talk about innovations to increase releases, recognizing that without lawful, humane, and timely releases, decongestion will remain an aspiration rather than a reality. But I hope to add some more. Recent data from the Bureau of Jail Management and Penology show that national jail congestion has decreased from historical highs of over 600% to below 300%. This decline represents thousands of individuals who are no longer crammed into spaces never meant for human habitation. It reflects the impact of paralegal assistance, plea bargaining, good conduct time allowance for study, teaching, and mentoring, and many others. Yet a congestion rate of 300% still means that a facility built to hold 100 persons holds almost 300. Nearly 70% of our jails remain congested, and more than 88% of detainees in BJMP facilities are still awaiting trial or final judgment, legally presumed innocent, enduring prolonged detention not as punishment, but as a byproduct of systemic delay. This tells us something fundamental. Congestion is driven less by criminality than by prolonged detention. The problem is not simply admissions. It is delay. It is the slow grind of proceedings and the fragmentation of responsibility across institutions. It is caused by a justice system that has a philosophy and that moves slowly for those who cannot afford speed. These realities compel us to confront the deepest question, one that delves not into only the problem of congestion, but into the very foundations of our penal philosophy and into the nature of punishment itself. Crimes are acts or omissions punishable by law. We all know that. The state has the coercive power to prohibit certain acts which are harmful to society and to itself and to its citizens. We are familiar with the 5 pillars of the criminal justice system: the system through our judiciary, the system of law enforcement through our law enforcement agencies, the system of prosecution through the Department of Justice, National Prosecutorial Service, and that in the Ombudsman. the system of correction and rehabilitation through the Bureau of Corrections, and through you, the Bureau of Jail Management and Penology, and community, primarily through the Department of Social Work and Development, and also through our legislature. There are three main schools of thought of why the state punishes crime. First, for the prevention of crime and society self-defense. Second, for the punishment of the accused, where the penalties are imposed to either deter others from continuing or to serve as retribution for vindication of the harm done. And third, for restoration or reformation. However, these do not touch on why the state is justified in imposing punishment in the first place. Philosophy professor David Bunin, and I am sure you're familiar with his work, calls this the problem of punishment. In his book, for example, The Problem of Punishment, Bunin asks, why does legal punishment allow the state to treat those who break the law in ways that otherwise would be morally reprehensible? Even if laws are just and offenders are neurologically responsible, why does a legal violation make it morally acceptable for the state to inflict suffering? How does the line between law-abiding and the accused suddenly justify deprivation, harm, and prolonged confinement? One solution that Bunin proposes is to consider victim restitution as an alternative to punishment. Victim restitution shifts the focus away from the state inflicting harm on those who have broken the law. Instead, he urges the state to consider what can be done to mitigate the damage already inflicted by the lawbreaker. For Bunin, this is called pure restitution, which consists in the conjunction of two claims: the claim that the state should not punish people for breaking the law, and the claim that the state should compel people who break the law to compensate their victims for the harms they have wrongfully caused and to introduce some form of rehabilitation. This theory relates to what is commonly referred to now as restorative justice. The present structure of our criminal justice system is anchored strongly on the principle of retributive justice, where a relevant consideration is the proportionality of the punishment imposed to the crime committed, but it has nothing almost to say about rehabilitation, restoration, and compensation. In the words of Bunin, legal punishment involves treating those who break the law in ways that it would be wrong to treat those who do not. Common arguments in favor of punishment rely on the consequentialist claim that the presumed benefits of punishment are sufficient to render it morally permissible. Perhaps many of you share this view and see punishment as a justified response to the wrongdoing our person has done. It is utilitarian in character, but there has been very little study, if any, to show that it does the consequences that it claims to do. The logic is that if a person who breaks the law is subjected to monetary fines, forced incarceration, and bodily suffering, then it will turn them away from committing crime. This establishes that an essential element of punishment is the infliction of harm. Punishment on this account involves depriving someone of what would otherwise be a right. Here we face a difficult moral dilemma. The very essence of our current judicial system seems to be rooted in depriving certain people of their rights when they fail to act in accordance with the law. This toes the fine line of human rights as it is merely granted, rather than something inherent in every person. The hope is that punishment will teach them not to break the law and turn them into law-abiding citizens. Whether in fact incarceration actually teaches them to do better Incarceration alone at that is something that we should reflect upon. But we know that it is not always the case. The Bill of Rights encompasses the rights and entitlements of all citizens. For any criminal liability or punishment to arise in our case, Section 14 of our Constitution expressly provides, no person shall be held to answer for a criminal offense without due process of law. At the core of this provision is the primordial presumption of innocence of an accused facing criminal prosecution. To be convicted, proof beyond a reasonable doubt is required. However, we have observed a disconnect in the treatment of citizens as they progress through the various stages of the criminal justice system. Let us examine the taking of a citizen under the custody of the law. Generally, they can be taken on the strength of a warrant issued by a judge or when they are caught in flagrante delicto. Hot pursuit, as believed by some law enforcers, is very strict. Hot pursuit is not the hot pursuit mainly perceived by many of our law enforcers. The institution of a criminal action typically requires a preliminary investigation or inquest based on the penalty of the offense charge. During this process, a citizen becomes a respondent who answers to the complaint filed against them. Upon conclusion of the preliminary investigation, the National Prosecution Service generally recommends the filing of an information before the courts. After the filing of an information, the citizen now accused may be arrested upon a judge issuance of a warrant. Although they may apply for bail, not everyone has the capacity to pay with monetary resources for security to be released from custody before their trial. Much of our bail is premised on the idea that everyone has the money to post bail. Institutional delays in court setting arraignments, pretrial and trial dates exacerbate the suffering of an accused awaiting the outcome of their criminal case. The burden of the delays, the congestion of our prisons, the inhumane conditions of punishment are all borne by an accused not yet convicted. However, these are all harms intentionally imposed by our current criminal justice system. A moral justification for this system is therefore necessary. The outcome of criminal trial has yet to be determined. Their guilt beyond reasonable doubt has yet to be established. Prior to their conviction, they must be presumed innocent, and the burden of proving their guilt lies with the prosecution. However, for many who are incarcerated, they are already being punished simply because they do not have the resources to avail of the avenues for release, and that is bail. Gaps in our system can lead to increased suffering for many of our people. And as many of the judges and justices here know, more than 90% of all criminal accused are from our poorer sectors. Tell me if I am wrong. I would want to be corrected. Restorative justice could address these gaps, providing our penal system with the principles and space to improve how it handles a wide range of cases. In restorative justice, the focus is not on punishment, but on a dialogue among the victims, the offender, and the community to develop a reparation plan. Punishment is not central to this deliberative process, which focuses on healing the victim as well as the accused and undoing the hurt. Healing the offender by rebuilding their moral and social selves, and healing communities and social relationships. This is difficult. This is complex. But so is our current judicial system. It is as complex and as difficult. Done right, restorative justice becomes foundational to the fifth pillar of our criminal justice system, one that we should have emphasized, and that is largely ignored. The fifth pillar should be the first: community. In 2020, at the height of COVID-19 pandemic, the case of Almonte versus People brought to light the rights of persons deprived of liberty, particularly the dire situation of congested jails in the country in a situation of a pandemic. It was at this time, in recognition of subhumane conditions of our detention centers, that the drafting of the rules called the Writ of Kalayaan was proposed. It is already drafted. I have already submitted it to the court. But there is such a strong pushback from our current premises of our judicial system that it is still undergoing very strident debate among the justices of the Supreme Court. In brief, the Writ of Kalayaan is an extraordinary remedy for PDLs created through the court's constitutional power to promulgate rules concerning the protection and enforcement of constitutional rights. Grounded firmly on social justice, it is patterned after the Writ of Kalikasan and the Writ of Continuing Mandamus used in environmental cases, with the aim of engaging in a more participative and complementary approach with the executive and legislative branches. It focuses attention on congestion in jails and prisons, giving them priority, making them feel visible, and addressing their needs using the necessary resources from various agencies and departments in charge. The Writ of Kalayaan recognizes that decongestion cannot rely solely on infrastructure or administrative discretion. It introduces a very rights-based, court-supervised mechanism that compels coordinated action. It brings together jail officials, prosecutors, public defenders, and judges within a single proceeding, focused on conditions, capacity, and compliance in specific detention centers. Thus, the writ transforms release from an act of discretion into a mechanism of systemic accountability. It aligns incentives. It encourages timely, creative action, knowing that inaction carries legal consequences. The writ of continuing mandamus in environmental cases proceeds as follows. Any citizen can file a case to call attention to an ecological disaster or one that is imminent. And the court, therefore, can issue mandamus to the executive and even the legislative branch to come together and come out together with a clear plan to address the imminent, impending ecological disaster. That has already been done in many cases. In one case, there is still the writ of continuing mandamus to clean up the entire Manila Bay. And here, the court invites the executive to quarterly make a report on their progress to clean up Manila Bay. The writ of Kalayaan similarly allows any inmate, any detention prisoner to file a case calling attention to the subhuman, inhumane conditions of a particular detention center, be it the space that they are not allowed or the food that they are forced to eat, or any other conditions before conviction or after conviction. The writ of Kalayaan allows the court to issue a continuing writ and compels the executive and the legislative to inform that court of what they are doing in order to make the conditions of the jail more humane. And therefore, it focuses attention on specific jails if not the entire system in itself. We do not substitute our discretion to actually provide the resources to improve the jails. But with the symbolic authority of the courts, it can compel the executive and the legislative to focus attention on people that they have or we have made invisible. You see, that is the function of jails. We find an accused and throw them somewhere where the public cannot see them. And that is called our jails. Our jails are located in areas that cannot be seen by the public. Their conditions are such that it is only the wardens and the guards that can see the subhuman conditions of these jails. And I pity the wardens and the guards because daily they see the subhuman conditions that our state imposes on their fellow citizens. Can you imagine the kind of humanity that they will have inhumanity that our guards, the BJMP, have to suffer on a daily basis? This second National Decongestion Summit is explicitly forward-looking. It calls for legislative action, a unified Penology Act, amendments to the Recognizance Act, a broader parole eligibility, and a stronger reintegration framework. I call for a fundamental rethinking of what our penal philosophy is. Are we a Filipino humane society or are we not? The writ of kalayaan is a fundamental way that the judiciary itself should recalibrate its role. By generating judicial findings on detention conditions, it produces evidence that can inform legislation. By requiring data-driven plans, it reinforces the need for monitoring. By foregrounding community participation, including the voices of persons deprived of liberty, it aligns with our shared commitment to broad engagement. I think part of our system, impliedly though not explicitly, assume that once you are an accused, you should be deprived of your own voice forever until you are actually declared to be acquitted. I think that is not correct. Most importantly, we should recenter the conversation on human dignity for all. Statistics matter, infrastructures matter, but dignity is and must always be the ultimate measure of justice, even for convicted prisoners. We must continue to open our minds and imagine even more ways to lessen the suffering of our people. The judiciary continues to fulfill its mandate, which is to pursue our reforms under SPJI. During our watch, let us not choose convenience over courage. Let us not choose to do what is here by inertia, but rather let us ensure that decongestion is not a temporary relief, but a necessary step forward towards a more humane, rational, and just penal philosophy, and therefore leading to a just judicial system. Thank you. Maraming salamat. Agyamanak. Shukran.
Thank you very much, Saj Leonen. The question and answer, you have any questions, will be at the end of everyone's talk. I'm sure you have many questions and comments. Our next speaker will surely add spice to our discussion. In fact, her very name alone will add salt on our discussion. Patrice Salton is the Executive Director of the Center on Race, Inequality, and the Law at New York University. If you notice your program, She's also a speaker at another session later on. She's also involved in DC Justice Lab. So he's multifaceted. And ma'am, love is pronounced in our country as lab. So she is also involved in played a critical role in drafting the district's comprehensive criminal code and overhauled and contributed to the record number of police reform informed by rigorous research and community engagement. Let's all welcome Patrice Sultan.
Thank you. It's so good to be with you. Thank you so much. Thank you, Nick and Monica, for bringing me here, and thank you to everyone who's here, who has carved out a third day to tackle a very challenging and important subject. My name's Patrice Sultan, and I have really spent my career focused on trying to get people to rethink who we punish, how we punish, and why we punish. And I've done that through a number of large-scale legislative advocacy projects, direct representation and other litigation, and other activism efforts in the United States. And I feel very lucky to be with you and to have learned from you and connect with you this week here in the Philippines. On Tuesday, I had a chance to visit a jail and a prison here. And with that time difference, it actually landed on Monday in the United States, which was the day that we have marked as a federal holiday to honor the life and legacy of Dr. Martin Luther King Jr. So I wanted to start today with a quote from him and with a confession that my vision of what justice means may be different or narrower than what has been discussed throughout the week here, but I think is very much aligned with what I heard from our first speaker this morning. And that is that I've heard the phrase justice must be firm but fair. And my view of justice does not really accept that firmness as a good unto itself. I believe in peace and freedom and love. I believe in reducing crime. I believe in victims' rights and agency. But I don't really believe in firmness or punishment for punishment's sake any more than I believe in violence for violence sake. And what we've learned from the last 40 years of mass incarceration in the United States is that toughness doesn't actually lead to less harm. It's actually driven our crime rates astronomically high, and I hope I can leave that evidence with you to consider. My hope is that I'll convince at least one person while I'm here that deprivation of liberty is either unnecessary or at the very least an effort of last resort. The United States is by far the leader in putting human beings in cages. There is no close second. But I wanted to at least take a look at how the Philippines measures up to what we're doing back home. And this is measured in people per 100,000 people. The United States is at about 614. And what I learned is that the Philippines is right here at 149 people in cages per 100,000 people who live here. So as we talk about expansion and capacity throughout the day-to-day, I want people to keep in mind where it ranks when we talk about the necessity of incarcerating people. And just know that it hasn't been necessary in every other place in the world. Where I can say the Philippines is doing better than the United States is the direction that you're facing, which is to say that your incarceration rates have declined in recent years, whereas in the United States, under the last administration, we actually started to take a turn in the wrong direction. I've heard a few different numbers for how congested the jails and prisons here are. This number comes from the World Prison Brief, and I realize is different than the number that's been talked about most of the time I'm here, which was somewhere around 214%. But as someone visiting you from far away, I thought I'd share how it looks and feels to me with respect to your capacity here. When I've worked on solitary confinement in the United States, we often talk about how small the cells are by comparing them to a parking space or an elevator. And people are shocked to believe that someone could live in a space that small. So in visiting the prison and jail here, to see 4, 5, 6 people confined to a space about the same size, without a toilet, without a sink, without a mattress, it felt like you were at 500, 600, 700% of where you really should be. I wasn't here to talk about that. I was really here to talk about the solutions to the overcrowding problem that everyone here knows much better than I know it. And there are really 3 different areas of law that I've worked on to try to advance decarceration efforts in the United States. One is the overbreadth of substantive criminal laws. That's how we think about how we define what is a crime, what is accomplice liability, and so forth. Then there's the over-enforcement of laws, which is how we police things, or even how we find alternatives like the grassroots community conflict resolution efforts I learned about here yesterday. And lastly, there's over-punishment and how we are relying on incarceration for periods of time that are much longer than what we should be doing. In the United States, we learned that we cannot do anything about our huge mass incarceration numbers that's meaningful without addressing extreme sentences. And these numbers are from back home, where we think about perpetual confinement in terms of life without parole, life with parole, or sentences that are de facto life sentences because they are measured in so many periods, in a period of so many years. And one innovation that we were able to promote that I get to talk to you about today is second look sentencing. The reason that we were able to persuade our legislative body in Washington, D.C. to adopt a second look sentencing scheme was really based on the impact that these long sentences are having on crime in the United States. Not so much a measure of leniency or concern about human dignity as it was that we're actually not doing a good job of that fundamental underpinning, the philosophy that you talked about that leads us to punishment in the first place. And I have had the opportunity while here to meet with several people who have sentences that are this extreme. And one thing I'll point out that was surprising was that a lot of their cases didn't actually involve death or serious bodily injury or even force or violence. And that is something that was unusual to me as an American, to meet people who had been imprisoned for 25 years for something that didn't involve a victim. This chart shows the second look sentencing schemes that have been adopted in the United States. And this really was born out of case law that we had in the US that said you cannot give people who are under 18, or children as we often call them, life without parole. And it empowers a sentencing court, not a parole board, to revisit the sentence that was handed down in a case after a period of time. And in a lot of places it has to be initiated by a prosecutor or corrections, but DC broke new ground by adopting one that applied to adults that put the power in the hands of the sentencing judges instead of prosecutors or corrections or a parole board. Essentially how it works is that if the court determines the person's not a danger to the safety of an individual or the community at large, and that the interests of justice warrant a sentence modification, the judge can reduce that sentence. The primary focus is maturity, rehabilitation, fitness to reenter society. It's looking at growth and it's looking at the community safety issues and not so much obedience, which is really the focus of something like good time credits. Our first version of an Incarceration Reduction Act bill applied to people who were under 18 the time they were sentenced, who had served 20 years. And we later, after seeing great success with that, raised the age to 25 years at the time their offense was committed and shortened the waiting period to 15 years. And if the person is denied, they can reapply again after 3 years. And defense attorneys and experts are available to people who can't afford them free of charge. The court will look at a number of personal factors in addition to factors about the case. So oftentimes experts in mitigation will come in and talk about the person's entire lifespan from childhood until the time that they're appearing for their resentencing hearing. And I had the honor of actually arguing the very first one that we had in the United States. And we learned a lot about what the court needs to be educated in to fully understand the picture of a person's entire life then and now. The factors that are normally considered at the initial sentencing also come into play at resentencing, including victim impact statements, statements and arguments from the prosecutor, and the nature of the offense itself, the extent of the person's involvement in it. We have had over 250 people come home under the Incarceration Reduction Amendment Act and the statutes that followed, and they are all contributing incredibly to our community in Washington, D.C. These are a few pictures of my friends. One is an artist whose paintings I cannot afford. One is a community nonprofit leader. Mama Lou is the one standing with Kim Kardashian, which I thought was fun to include. And Jean on the left is a really talented spoken word artist and community leader as well. The main thing that I wanted to highlight is that this is fundamentally different from parole because it's putting the power back in the hands of judges who are best equipped to determine what a person's sentence should be. And the idea here is really not so much about leniency as we would have with certain other post-conviction relief in the United States. It's really about complying with the original law. There's no way to know at the time someone's being sentenced whether that sentence is fashioned well enough to meet the objectives of the law. One joke I make that might be in poor taste is that the United States has a very, very high divorce rate, you might know. And so we make lifelong decisions often that we believe are going to hold up over time, only to decide later that that isn't something that we would have agreed to do had we known then what we know now. These provisions are really borrowed from DC specific law, which might vary state to state, but in DC, the sentence has to reflect the seriousness of the offense, provide for just punishment, afford adequate deterrence, and provide educational and vocational training, medical care, and other correctional treatment. I also like to include this in a lot of the motions that I write at the time of sentencing and resentencing, which is that the court really should have as much information as it can possibly have in order to decide what should happen when someone's freedom is deprived. And so any argument that we should decide things swiftly when it comes to the deprivation of liberty really are misplaced. When we learn something new, the courts should learn that too, and this is an opportunity for them to do so. Some of the provisions that you'll see if you look at some of the leading organizations that are pushing for this to expand across all 50 states include making sure that these provisions are retroactive and apply to cases from a long time ago, that people have the right to expert witnesses who can explain particularly what it's like to live inside a penitentiary in the United States, that the hearings are evidentiary. You can call witnesses and present testimony and they happen on the record and they can be appealed, and that there's a written record of the court's reasoning. On the left-hand side of the screen is a set of recommendations that came from the New York State Justice Task Force last year, which is where I live now. And I wanted to highlight that the recommendation there and elsewhere is to have this review happen much earlier than what we piloted in Washington, D.C., and to initiate second look sentencing in 5 years instead of 10, 15, or 20 years. And there are some other provisions there that might be very helpful as you look into adopting something similar. I included some resources from some of those leading organizations that I just mentioned, but in the interest of time, I'll move forward so that we can hear from NID. But one thing that I do want to mention before I leave is that I will say that the most surprising thing that I heard throughout the week visiting you from the United States was that plea bargaining has been discussed as an alternative to incarceration. And I didn't want to leave here without letting you know that in the United States, without question, plea bargaining is one of the biggest drivers of mass incarceration. If you look at the first graph I showed at the beginning of my talk here, that ballooning happened around the time that we desegregated our communities by law, but it also got much bigger when we started having people plead guilty. And my expectation, based on what we've learned over those decades in the United States, is that you will, in the short term, see some decongestion of your trial courts, but you will absolutely have more people in your jails. And you will have people there who have pled guilty to things that they did not do. And you may even see some new backlog in your courts of appeals. It takes hours to explain to someone what rights they're giving up when they decide to enter a plea of guilty to a criminal charge. And from what I've learned this week, the attorneys who are tasked with defending people in criminal courts in the Philippines do not have time to meet with their clients for trial, let alone the time to meet with them to explain to them to give their trial rights up. So I would really encourage you to proceed with caution when thinking about plea bargaining as an alternative to incarceration. And I'll also highlight these hidden drivers of incarceration that I'm happy to talk to anyone about separately, that we've seen really balloon our numbers in the United States. But just know that things like electronic monitoring account for a huge part of our prison population. Almost a third of that long bar is people going back to prison for violating conditions of release. And again, it just moves us into that model of thinking about obedience instead of thinking about community safety, dangerousness, well-being, growth, and maturity. So a cautionary tale there as well, and some encouragement to learn from what we've done wrong back home. I know there will be some discussion about compassionate release and that there was some discussion about diversion already, but I wanted to at least note what the scope of that is in Washington, D.C. And I want to address what I imagine most people are thinking, because this came up even when we did second look sentencing in a country that has 4 times as many judges per case as you have here, which is how would we possibly have more hearings with the amount of work that we have to do now? And I would encourage you to think about pairing a second look reform with a serious look at how speedy trial rights are enforced in the Philippines. As big and barbaric as our system might look, I think if you polled the average American and said, what should happen if after 5 years the person is still sitting there pre-trial, they would say their case should be dismissed. That the person's individual human rights and interests are more important than that firmness, that toughness that we're demanding when we don't look at the full picture and just think about the individual harm that happened in that case. So I've included the language, and this is actually one of the few things that the court rules address instead of having to go through the legislature back home. And we have a rule that just says the court has authority to dismiss petition for want of prosecution if there's unnecessary delay in filing the petition or bringing the case to disposition. And we argue that at hearings all the time. You would not have somebody say, this case is being reset year after year after year without lawyers jumping up and down and saying the case must be dismissed to protect the rights of the accused. We heard already from some great speakers about some of these other moments. I was allowed to leave a message in the message book at the jail before we left, and this is the quote I decided to include there, and I'll share it in closing with you also, which is, in recognizing the humanity of our fellow beings, we pay ourselves the highest tribute. And I thank you so much for your time and invite you to connect with the center and stay in touch with me.
Thank you very much, Ms. Sultan. Our next speaker is a senior advisor of the Asia Pacific representative of the Association for the Prevention of Torture. He is also based in Bangkok. His focus is on promoting dignity and fairness in the criminal justice systems, advocating for human rights-based policing and systemic changes to reduce risk of torture and ill treatment in the first moments of detention. He has worked as a public defender in criminal courts, a legal advisor across the Pacific Islands, and a human rights advisor within the National Human Rights. He holds an LLM in public international law and fluent in English and Thai. Let's all welcome Mr. Nid Sajidapon.
Hello, good morning, everybody. I'm just going to check the technology works. Great. So, what a great morning that we've been able to start with today, and I'm very honored to be able to come here follow my distinguished speakers, as well as to speak to such a distinguished audience as well. Also wish to thank the those who brought me here, the JSCC in particular. It's such a great initiative to see leadership from the justice system putting this. And of course, a big thanks to the UNODC team. What a great conference we've had so far. Now, my angle today is going to be a little bit different because it's in our name. We are the Association for the Prevention of Torture. A little bit about us and why I'm here. We're almost 5 decades in existence. We're founded in Geneva, Switzerland by a man who had a very simple insight that torture and ill treatment happens behind closed doors, similar to what His Honor said before. I say ill treatment as our short form for, you all know already, cruel, inhuman, degrading treatment, punishment. It's going to take 2 hours to say that every time. So his idea was very simple. We wanted to start an organization to promote how we can reduce these risks of torture and ill treatment. And the first answer was to open up every place of deprivation of liberty to outside monitoring. He designed what was called, at the time, the European Convention for the Prevention of Torture, which has now been translated into the OPCAT, another topic that I think many of you are familiar with. But today, we now work on quite a lot of different themes. And one of this is what I'm here for today. I'm going to skip past this. I don't think you all need to read the convention, but I put it up there just to say that our starting point is that it is a state obligation to actively prevent torture and ill treatment in your jurisdiction. This is not me saying it. This is, I have to look into the history, which president of yours that went to Geneva and deposited the instrument of ratification. But this was a state commitment. But so as I said, every time I introduce our name, everyone, particularly from the state sector, says, oh, torture prevention, okay, what are you here to do? And so we're not that scary. And put very simply, preventing torture is about reducing the risks and creating environments where torture and ill treatment is less likely to happen. I preface this with a little bit of somber news, I guess, that we acknowledge that we can never fully eliminate or eradicate torture and ill treatment. It will happen, but our vision is the best that we can do is to reduce those risks. And we need to work together with the state to reduce those risks. And in doing so, we focus on these 3 goals, or the 3 risks. One is recognizing that where there is a lack of independent oversight, this is where we need to fill that gap. 2 is what I focus on, fairness and dignity in the criminal justice system. And 3 is to focus on the people in your society that you would consider have particularly heightened risks. And in each country, who those people, those groups of people are will be different, whether it's by age, sex, gender, sexual identity, orientation, social status, religion, political identity. And so for my session today, I want to focus on these very crucial moments of decongestion, and it's on the moments of pretrial detention, police custody. I take it from the statistics we've all been hearing. So we have approximately 65% of the total prison population in the Philippines that are under pretrial detention right now. So charged, arrested, awaiting trial, not been convicted yet. And then I was asked to give this topic about, innovations to increase their releases. I suppose the first question has already been answered by my 2 esteemed colleagues about, breaking these myths about, oh, well, why should we increase their releases? Aren't they dangerous? Don't we need to protect the community? Don't we need to punish them? I just want to echo what the 2 speakers said this morning, as well as many of those that spoke yesterday already, that debunks these myths. And then going forward, I want to share with you we have this key research that talks about whether torture prevention even works. And in 2016, we hired some independent researchers to look into our work for 40-ish years, to look at what works, what doesn't work. Firstly, with the key findings, and it's what I mentioned, that torture prevention is still going to be needed, and the risks are particularly high in police custody and in systems where coercion and interrogation is still the norm. And then, of course, the culture, the national culture, is what is going to drive or enable those practices. In that same year, the former UN Special Rapporteur against torture, Mr. Juan Mendez, so he himself is very interesting. He's Argentinian, also a survivor of torture. We collaborated with him in his final year, where he also shared the observation that the most high instances of torture and ill treatment are in pretrial detention, in interrogations, in what the purpose of obtaining a confession. So what we often hear when we say this is, no, we don't do this. Or, look, we have a lot of pressure. I earn this many pesos per month. My boss tells me I have to produce this many arrests per month. What am I supposed to do? Or, no, I would never do this. No, it's unrealistic to suggest human rights-based policing or human rights-based corrections. And, okay, that one thing that you saw in the news, that's this thing that happened in the province. We don't train people to do this. But I guess, look, you don't need to hear from me already about the presumption of innocence, and the job of law enforcement and the job of corrections is not to affirm guilt, but it is to enforce the law, to enforce the sentences. And as I said, preventing torture is not about being friends with people who, in an adversarial system, you wouldn't consider them to be friends, but it's about how to create environments to reduce this risk. I'll try and break that. I just want to know if anyone has some ideas. What do you think, then, can reduce the risk of torture? Anyone willing to put their hands up? That's all right. We'll get to Q&A later. But the research that we commissioned showed all these things, and each line that is on the screen now is a separate topic that we can workshop for about a week. So I want to focus today just on the fourth line, which is prompt appearance before a court. I think you heard a few people talking about this word, custody hearings. And what do you mean by custody hearings? And so the starting point is Article 9 of the ICCPR, that everyone is arrested must be brought promptly before a court to challenge the legality of the detention, determine whether they need to be detained or not. And I have a follow-up question about, and this is a genuine question, I think. It's for me to know, what is the average time that a person in the Philippines spends before they have the ability to apply for bail? Should my colleagues from the UNODC? Yes, sir? 3 months. So 3 months. For me, that's quite shocking. But we're here to find solutions. We at the APT in 2014 collaborated with the Brazilian National Council of Justice. So similar to what you have here as the JSCC. We helped the council design this thing called a custody hearing, and I want to share with you our experiences, our statistics, and what progress has been made since then. In Brazil, through a national resolution from the council, there has now been I think I can still say it's new, it's been 11 years. New form of hearing, which we call custody hearings, and the purpose is threefold. One is to analyze the legality of the arrest. Two is to consider the necessity of whether that person needs to be taken to pretrial detention or not. Three, which is where we were the most, was pushing for the most, is to empower the judges to be a little bit more inquisitorial at the first appearance to screen whether there are any signs of torture or ill treatment. So in practice now, in Brazil, generally a person deprived of liberty is brought within 24 hours for the purposes of this custody hearing. And this is a huge transformation. Here I have some benefits, but I think you already know what the benefits are. But I want to, I think especially for our members of the judiciary, you may be curious about how do these hearings work, what happens, what can they look like in practice, can this be done in the Philippines? The first thing is that in today's age of technology, and there is a lot of discussions about electronic hearings or virtual hearings, custody hearings, from the torture prevention perspective, we believe that it should still be in person. Part of it is for the screening that the judge will do, speaking directly to the defendant, asking about the circumstances of the arrest, what His Honor just said, was it actually in flagrante, or was it something else? What were the reasonable grounds to arrest? And of course, for us, what harm, what use of force, what level what was necessity. So generally, at these hearings, we hear from the person deprived of liberty, the lawyer on duty, the court duty lawyer, and the prosecutor assigned about the circumstances. We then evaluate the legality. Was there abuse? Was there ill treatment or torture that occurred within these past 24 hours? And then the judge will determine whether to remand that person in custody until such a time as a proper bail hearing can be made, which I'm thinking back in Brazil before this happened, it was generally around 2 months. 2 months until awaiting a bail hearing. And a proper bail hearing can still happen later on, but at least this enables sort of an interim measure to see whether this person even needs to be in custody or if they can be released on conditions. And then, or indeed, whether there can be alternative measures. Secondly, the judge verifies the safeguards that you're all familiar with, that is in your constitution. Was the defendant informed of their rights? Did they have a chance to speak to a lawyer, a public defender? Have they been opportunity to have medical examination, communicate with families, third party, doesn't need, and indeed whether they have been brought promptly before the court after arrest. And these are all safeguards which, going back to that research that I mentioned, shows that when properly implemented, it significantly reduces the risk of torture. Or another way to think about it is that it creates a national system where torture or any kind of ill treatment is less likely to happen. When there is an allegation that something bad has happened, the judge will then send a copy of the transcript to public prosecutor's office, send a letter to internal affairs. So the agencies that are responsible for investigating and prosecuting torture as a separate stream. Certainly, don't get me wrong, it doesn't mean that the defendant right now will have all the charges removed, if some of you are concerned about that. But it just means that two parallel things can happen at once. Two things can be true at once. And when we show this, often members of law enforcement ask me, oh, okay, so you've got this great hearing system, and a defendant can come up and say, oh, yes, Your Honor, the police beat me up before I was taken here, or they threatened that they will get my family if I do not confess. So that they, with the aim to say, oh, let's just release me. Isn't that what everyone would do? So surprisingly, no. We have, part of our ongoing work in Brazil now is sending project officers around the country at different regions in different states and cities to observe and collect data on these hearings. So this was the latest one where you can see on the top line, we had a colleague observe 55 custody hearings last year in Mato Grosso. Of the 55, 15 PDLs alleged that there was some kind of torture or ill treatment. And you can see the trend overall. The highest is around 31%, the lowest is 16%. Now, I'm not going to go into the details of, we have much more data about of the allegations, what is proven, how many are released, that kind of thing. But from those of you who are sociologists in the room can probably tell the room better than me why it is that everyone is not alleging that some kind of ill treatment happened. And so 10 years of data tracking in Brazil now, I just want to share that even if, let's say, we don't, putting aside the benefits of torture prevention from my organization, the second benefit we have seen very clearly with implementing custody hearings is that in 2014, 40.13% of the prison population in Brazil were in pretrial detention. As of last year, it is now 23%. Now, I will acknowledge that the reduction, the almost half of the numbers, can be attributed to other measures, possibly. But, I mean, we like to think that the introduction of custody hearings is a huge factor in forcing the system to enable and to actually sit down and consider, does this person appearing before the court with these charges actually need to be in custody, or can there be an alternative to pretrial detention? In short, custody hearings are all about determining rights, the legality, and the necessity of detention. There are all these benefits that I've listed here, but in a room full of many people from the state sector, what I like to say is that one of the biggest benefits in whether it's custody hearings, decongestion, or human rights-based policing is that you see a country or a population that has trust and confidence in representatives of the state, in the state institutions. And I think that is a huge driver of why change should happen, and it's beneficial for everybody. That's all from me from this morning. Thank you.
Thank you very much, Mr. Sajidapalon, for such an interesting discussion and talk. Reminders for those who have questions, please indicate the organization you're representing, if any, and the position that in what capacity or you are in that particular organization. So, are there any questions? Just approach the microphone in the middle. Yes?
Good morning, po. I am Giselle Geronimo from the City Prosecutor of OCP City of San Fernando in Pampanga. I have two questions po for Justice Leonin. Justice, you mentioned about the writ of kalayaan. I was just wondering why is there a strong pushback against on the writ of kalayaan despite the presence of inhumane detention conditions? Is the resistance rooted in legal doctrine, political issues, or institutional inertia? And the second question, Justice, is about the proposed or the draft amendments to the rules on criminal procedure, which embodies the reforms such as custodial hearing, are already incorporated. Any timeline po as to its approval? Thank you po, Justice.
With the revised, the revision of the rules on criminal procedure, had I had my way, we will approve it in a few minutes. Except that, of course, there are so many things that we need to discuss there. For example, yes, custodial hearings. Also, the one appeal concept, the concept of bail, etc. and reflecting on what has been mentioned just a few minutes that we have had this conversation, I have a few ideas, having seen the revised rules, as to what else to propose in terms of the improvement of the language that we currently have in the revised rules, specifically the ones on bail, custody hearings, and in fact, even visitorial rights. So let me just mention, as a prelude to the answer of the first question, I mentioned to a judge, not the court administrator, but she's at work now on what I requested. I mentioned that to a judge that we might come out with a specific rule. You see, every judge in the Philippines is required to visit the jail, visit the detention center, every judge, not only the executive judge. But there is no guideline as to the checklist or what they are supposed to look at. And more importantly, there is no guideline as to what they will do if they see that there are human rights violations, constitutional violations, etc. So I mentioned this to a judge, and the reaction of the judge was, and this is not all judges, this is just one judge, hindi ba duty yan ng prosecution? Hindi ba duty yan ng BJMP? Hindi na judge. Ang nakalagay lang sa rules that we visit. Eh sabi ko, bakit kayo bibisita? Ano kayo? Makikikain, etc. So bibisita kayo because part of our role as a judiciary is that we should be, according to the Constitution, proactive in constitutional rights. The 1987 Constitution was different from the 35 Constitution. The 1935 Constitution states that we should be proactive in Section 5, Article 8 of the Constitution with respect to the protection and enforcement of constitutional rights. Therefore, when a regional trial court judge visits a detention center, and by the way, hindi lang BJMP yan, meron din yung provincial and LGU. When they visit a center and they see that there is somebody being tortured, or the food that they eat is, they call it grava rice. And I know you know, all of you know this. What is grava rice? For our foreign delegation, it is rice with a lot of pebbles. In other words, in order that they buy the cheapest rice for the detention prisoners, they buy the rice with pebbles in it. So that part of the time for eating of the detention prisoners is to separate it. And correct me if I'm wrong, Mandaluyong Women's Correctional. I hope I am wrong. I hope the person that told me is wrong. But this person used to be a detainee of that detention center. Please take note, BJMP and DOJ. But my point again here is, we have to be proactive. That is the pushback. They are saying, we in the judiciary should always exercise some level of restraint. We in the judiciary should always know that our role is only at the end of the entire thing, meaning to say after they promulgate the rules for administrative, legal, etc., ours is to be passive, to wait. But my perspective is different. In a condition, in a culture and a political economy like the Philippines, where a lot of our people are impoverished, unequal, disempowered, and that there is, or there can be, I'm not saying that there can be a democratic deficit. That is, the representatives in our government, be it legislative or executive, the judiciary does not represent a constituent. The judiciary protects a majority of one person, the plaintiff or the defendant. And when the judiciary acts, they don't care whether that person has money, that person is well-connected, that person is a politico, that person is rich. In fact, in the judiciary, when there is a petitioner who is very poor from the vulnerable and marginalized sector, that person becomes a majority of one. We listen, and we listen to what rights are violated. And that person, through the judiciary, can give an order, and that order is to protect their rights. And I think that is supposed to be the perspective. You see, many of our lawyers still think that we are part of the United States, with apologies to our colleagues from the United States. That is, that we are the judiciary is fully separated, and therefore the judiciary should exercise what Alexander Bickel called in 1962 in his book, The Least Dangerous Branch, and what Oliver Wendell Holmes said when he discussed the role of the judiciary, that it is the most passive of all. But again, I ask our Filipino, all of us here, what do you do in a country like ours where we have this kind of a political economy? And jail wardens, the guards, can see the inhumanity that is happening. Judges know that whenever they send somebody to this detention center, they will live with 300% congestion. And I say that that's average, by the way. There are situations where it is still 1,000%. And therefore, when the judge issues an order of commitment, they know and that they will send this person there. And can you imagine the kind of suffering that our wardens, our guards, our judges also suffer, but nothing compared to what that other person is suffering. So in brief answer, it is that. And it is formalized in language that reproduces certain myths, separation of power, the role of the judiciary, etc. And to me, in my mind, whatever the judiciary does today is not permanent until the year 3 million. Whatever the judiciary says today can always be adjusted when we improve our executive, legislative, administrative systems. But we cannot pretend the ideal, that everything is working right now. And therefore, to me, they call me an activist judge. I don't care. You call me by any other name. But I will call myself a justice of the Supreme Court. And again, I'm sorry that I took so long. I'm telling everybody judge and justice. They don't call you lawyer. They call you justice. And therefore, what our result should be is justice. Not the rule of law, but the rule of justice. And we look at the law because we have to acknowledge the text. But if the text can be read in such a way that we can produce custodial hearings, very nice idea, very progressive idea, then we should do so. So again, my commitment is to take a look at the revised rules based on the suggestions made right now by some of the speakers. And by the way, plea bargaining. So we have plea bargaining with Estipona versus people. Judges know what this is. The court imposed plea bargaining for drug-related cases. I hope you understand what the conditions were when the court decided Estipona versus people. But nowadays, people with only possession of a small amount of drugs, okay? And I tell you, I've sat in the Supreme Court the longest among all the incumbents. I have sat for 13 years. The chief has sat for 9 years. Justice Ben sat for 10 years. And in my stay there, it is very rare that we find more than 1 kilo of shabu. The usual amount is below, judges, tell me if I'm wrong, 1 gram. I have even decided on a case, 0.001 gram of shabu. And according to the conviction, it passed all 4 tests for chain of custody. You know what the 4th test is? You give it to a forensic chemist, and the forensic chemist will return and make the finding of what chemical it is. They gave it to the forensic chemist at 0.001. It came back to the judge, 0.001. Tell me if I'm wrong, that there is something wrong with that. We acquitted and ordered the release. My point again, Estipona says they go on plea bargaining. So somebody caught with 0.04, 0.05 nowadays, and I agree with our our colleague from the United States, would be thinking, they would be looking at the risk involved. Okay? Will judges, after my judge, will the Court of Appeals and the Supreme Court affirm the conviction of this judge or not? They are put in that dilemma simply because they were caught with 0.05 grams. Okay? So my point again is, why don't we rethink the penalty for possession? Why don't we rethink whether possession of marijuana should be something that we criminally punish? That's not for the judiciary, but, medical marijuana, cannabis, it's only the foreign delegation that clap because the judges here know that it is still illegal. But I will tell you, you have the right to remain silent. Everything you say can or will be used against you in a court of law. So I think it's also the perspective. So in brief answer, it's the perspective. And yes, we commit to take a look at the revised rules of criminal procedure. But let me invite you. If you know already the current version of the revised rules of criminal procedure, and you did not have the chance to send over your comments, please send it over to my chamber so that I can also add to the commentaries that I have already made to the proposed revised rules while it is pending adjudication. We want the rules to be amended by this year, and hopefully before the bar exams in September, in order that the bar examinees will suffer. Because our Filipino guests know this, they will have to review the entirely a new rule. I'm just joking. Yeah.
Thank you very much. Before we go to our next speaker, next questioner, I'd like to remind everyone, and I forgot this earlier, that our two resource persons are also lawyers. We have only time for 2 more questions, and the ones standing here now will be entertained. Sir?
Good morning, Justice. Ako po si Raymond Narag. Ako ay isang PDL. Nakulong po ako ng 6 na taon at 9 na araw. And I'm also now a professor of criminal justice at Southern Illinois University. Ang tanong ko po, my question really is from the perspective of a former prisoner. My colleagues were at the Manila City Jail 2 days ago. A jail for female dorm is designed for 187 PDLs. When we saw there, it's more than 1,000 PDLs. It's very horrible. The conditions of confinement is really, really deplorable. Umiiyak po yung mga kasama ko. They were crying. I could see in their eyes that this is unacceptable in another country's perspective. From a PDL, however, justice is, how can we challenge the condition of our confinement? We suffer it every day. But where is our recourse? Can we file it to the judge? Can we file it to the Court of Appeals? Can we file it to you directly? Is there a mechanism for us to challenge the wayward situations that we are made to suffer every day? So that's my direct question, Justice. Thank you very much.
Thank you, Raymond. I know your case, and I read most of what you write, including the last one that was published in Rappler, and I agree with you. Okay, what are the existing remedies? Right now, there is post-conviction habeas corpus, and there is habeas corpus before conviction. But habeas corpus can allege inhumane treatment because the wording of our Constitution says that it is not only cruel and unusual punishment, but also inhumane and cruel and unusual punishment. In fact, the commissioner that introduced inhumane was a commissioner that I worked with. I worked for. I was research assistant during the 1986 Constitutional Commission. This is Rene Sarmiento. What we are trying to add, because when you file habeas corpus as a detention prisoner or as a convicted prisoner, what happens is if it is granted, you are the only one that is released. And nothing happens to the conditions of jail. Okay. And usually, you do not want that to be the result. So therefore, that is what the writ of kalayaan is for. It means any single prisoner can file something like habeas corpus alleging inhumane conditions, and what the court does is take cognizance of it and gives the legislative and the executive and the LGU an opportunity to be heard, and for everybody to come out with a clear plan to decongest, with a clear plan to make it more humane, for the court to approve and supervise. Again, that is what the writ of Kalayaan is all about. It was it became a reality during the time of COVID. Because during the time of COVID, can you imagine that place that had 1,000, not 187 detainees, how they were able to survive? And I do not know, I saw the BJMP here a while ago. I am not sure, but I think a lot died or suffered during the early part of COVID. I think that was called Delta, etc. Okay. The other thing is, I think what the people can do is to lobby for better laws. Okay, let me give you an example. Do you know that in the Philippines, when you commit an infidelity to your wife or husband, marital infidelity is punished by 6 years and 1 day to 12 years. Of course, you apply indeterminate penalty. And my question there is, you're adding one more person in jail due to infidelity. And how dangerous is that person to society that you have to put that person in jail? In other words, are other women endangered simply because he committed infidelity to his wife? Or reverse, are other men endangered because she committed infidelity to her husband? And by the way, that 6 years is only applicable for men. Okay? And lobby for new laws, because in this country, we still punish adultery. And adultery is punished by 4 years. It's prison correctional, medium, maximum. Okay? And you know, for the man, for the husband, that's for the wife, by the way. For the husband, he cannot be punished with adultery. He can only be punished by concubinage. And not only sexual congress, there is an addition of scandalous circumstance. And you know, concubinage has a lighter penalty than adultery. Now tell me the logic of having to punish somebody who has betrayed his or her promise to the husband or the wife. Why do we punish it? And you know why? Because we copied the Spanish Code. In spite of the fact that Spain has already repealed it. And my question, therefore, is, we have so many laws. Unjust vexation, 1 to 30 days. Unjust vexation. In other words, inisin mo lang isang tao, unjust vexation is undefined, by the way. That is how it is put in the law. Unjust vexation. There are no elements. And therefore, to me, it is so vague. But nobody has challenged its constitutionality. How do I know? I've been waiting for somebody to challenge the vagueness and unconstitutionality of unjust vexation. I have been waiting for somebody to question the unconstitutionality of adultery or question the unconstitutionality of criminalizing infidelity. This adds to it. And my favorite, of course, is illegal gambling. PD 1602. PD 1602, where the penalty is also years, not months, not days. When you participate in tong-its on the streets, you can be incarcerated. But when you play in the casino called Soler or Resorts World, you are not incarcerated even if you bet millions of pesos per bet. And the reason for that is because our laws also create franchises for casinos, and our poor fellows, our poor kababayans, cannot enter casinos. So what they do is, simply out of boredom, simply because they have nothing to do, they play with 5 pesos, they play with 1 peso, and we punish them because we say gambling violates our moral values. But only the moral values of the poor. But for the rich, they can go to Soler. And my point there is, this adds Gambling. Ask any judge. Meron pa din. Gambling, unjust vexation, oral defamation. Nagmura lang siya, oral defamation. Pwede siya makulong. So those add to it. And the very stiff penalties for drugs that we have for possession, for sale, etc. So that therefore, that is what is increasing our courts. And the last thing, Raymond, is we have to address the causes. Why are there so many rape cases in this country? And I tell you, and any regional trial court will tell you, that almost on a weekly basis, they will have rapes. And for me, every deliberation of every division and every bank that is weekly, we have to tackle many rape cases, many of them incest. We have to address what causes it. So we don't only address the decongestion, we address also our remedies and reliefs. We have also to address the causes, and most importantly, address the question, why do you need to incarcerate somebody that played tong-its on the streets, or somebody that has been disloyal to the wife? Isn't it enough that they have civil remedies, etc.? So those are my questions. Thank you for that question.
Thank you very much. Judge Marvick Leonin would like to remind that the writ of kalayaan is not an available remedy to an unjustly detained spouse in a loveless marriage. Next questioner.
Good morning. I'm Joe Vendeliosa. I'm the executive judge of Mandaluyong City. I felt compelled to rise because of the reference to Mandaluyong. Saj, let me assure you that the Mandaluyong City Jail is compliant with the Mandela standards. Our congestion rate is negative 66%. As of January this year, we only have 341 male detainees and 56 female detainees. At the CFU of the Philippine National Police, we only have 50 detainees waiting for the information to be filed with the court. Every quarter, all our judges visit the city jail. However, we are unable to visit the Correctional Institute for Women because it is a prison, and any visit to CIW would require the permission of DG, Director General, Katapang. If this is let me assure Saj that by next week I'll coordinate with Superintendent Sanidad, who is also here, that I'll visit the CIW. And maybe the court may consider to, direct us judges to also conduct inspection of prisons in our jurisdiction if this is a source of concern. Thank you, Your Honor.
Thank you, Judge, and I commend the judges of Mandaluyong for making sure that their visits in prisons are very productive. Again, as I said, we have requested the Office of the Court Administrator to kindly come out with a draft that the court can consider with respect to what else to look for in terms of visitorial rights. In other words, it is not only the rate of congestion, but maybe the living conditions, including the kind of food that is being served. We also acknowledge that you cannot visit a prison because that is strictly not within the rule. And we are only covering the detention of people that have not yet been convicted. And we will look into your suggestion and see the repercussions of putting in our rules that judges also have jurisdiction to visit prisons. Of course, this will be in consultation with the DOJ. But knowing General Katapang, who is a member of the Committee on Human Rights, including Dr. Narag, who is also a member of the Committee on Human Rights, and his initial position was on the writ of kalayaan, he was fully in support of the writ of kalayaan. But of course, the DOJ changed its position on the writ of kalayaan. the good director did not. And I know that I feel, just looking at General Katapang, had it been his choice, he would release so many of those that are being detained right now, except that he cannot do so because he will be also imprisoned for violating his own duties under the law. But yes, we will look into that. We will also look into that suggestion. But as I said, Judge, maybe you can work with your RCMs and then the OCA to try to come out with suggestions. When you see a violation, what can you do apart from giving a report? And should that already be in our rules? Because our rules only require you to visit, but it does not tell you what to do in case there is something that is afoot. Maybe visitorial rights is a more proactive version of custodial hearings. In other words, that the judge itself can go and see the same things that custodial hearings will require of a judge when it is being committed. Maraming salamat.
I'm sure you have a lot more questions and reactions, but unfortunately, we have no more time. So a round of applause to our speakers today. Thank you very much. Now the floor to our
Thank you very much, Justice Martin, and to our panelists this morning, Senior Associate Justice Marvic Leonen, Nid Satchipanon, and Patrice Sultan. So at this point, we are running behind by about 30 minutes. So we will proceed. I trust that you have had your merienda this morning already. So we will proceed to the breakout sessions. For session 1, reintegration programs, that will be held at Rigodon Ballroom 1, the first door when you exit to your right or to your left. The session will be on reintegration programs. Session 2 on penal alternatives, recognizance and compassionate release, Rigodon Ballroom 2. For the third session, expungement of criminal records, that will be here in this ballroom. And for the fourth session, prison audits